Thank you, Your Honor. My name is Jennifer Kennedy, and I'm here on behalf of the appellant, Mr. James Moore. Your Honor, at this time, I would like to request 5 minutes for rebuttal, if I could. Thank you. This case is initially an appeal from the trial court's denial of Mr. Moore's petition for modification or termination of his alimony following retirement. There are 3 issues raised. The second issue deals primarily with that modification or termination denial. However, the first issue, which if the court, unless the court has another direction it would like to go in, I would like to address is there was a request or a motion to disqualify the trial court judge during the proceedings in this matter that was denied. That is the first issue that we raised.
Can I address something out of the gate here about that?
Absolutely.
I'll ask opposing counsel, do you acknowledge that there was a petition for writ of prohibition taken from the denial of the motion to disqualify?
There was not, Your Honor, no. And I can clarify if I can clarify.
Thanks.
And again, I don't want to go outside of sort of this particular record, but given Your Honor's question, I anticipate that there's, you're aware of the court's docket and the proceedings that were subsequent to this involving the court. This petition, or this motion to disqualify, there was not a writ of prohibition taken. What occurred, and what I believe Your Honor may be referring to, is subsequently there were additional things that occurred during the trial proceedings, including during proceedings with regard to attorney's fees that gave rise to subsequent motions to disqualify.
Did that subsequent motion incorporate the facts of the first motion? Not incorporate, but did it rely on them as well?
It certainly referenced those as acknowledging that given the case law, a motion to disqualify has to be brought almost contemporaneously with when the statement or the conduct is made. So there was an acknowledgement that, hey, these prior comments are kind of contextual. They put these additional comments in context.
But they were time barred. The reliance on them was time barred, or
correct. But so in other words, and I may be
okay. So we can move along. I don't want to interrupt your argument. So there was a subsequent.
There were subsequent. Yes, there were 2.
There was no timely. There was no prohibition petition made at all regarding the one you're arguing now.
Not with regard to this. No, Your Honor. And I will just to just one point clear because. Or to anticipate kind of what will be coming. There have been, I would anticipate the argument would be, well, the court denied the motion to disqualify, or the petition for writ of prohibition with regard to the 3rd motion to disqualify. I know there was a 5th, so let's say the 5th. The 5th motion to disqualify, writ of prohibition, referenced, hey, this has kind of been an ongoing issue. Here are these prior. I believe trial counsel, when the motion was filed, with the court, referenced all of that and attached all of that, so that went up. But when this court would have been, my understanding of the law is when this court would have been reviewing that writ of prohibition with regard to the 5th motion to disqualify, the court is going to be considering those particular statements that gave rise, contemporaneous or within to that motion. So these events that occurred in some instances like a year, 2 years prior to that occurring. So although there's reference, again, in the answer brief to the writ of prohibition not being filed, I believe, as this Court's aware, while we can take a writ of prohibition, this Court has also found that it's proper to challenge a denial of a motion to disqualify on appeal, which is what we've done with regard to this particular motion to disqualify. And in that regard, Your Honor, the law is very clear that and gets somewhat dramatic in how it says that, the quote is that every litigant is entitled to a cold and impartial judge. I think this is
But the law is also clear that adverse rulings aren't legally sufficient. And there must be things that have occurred that a reasonable person would think they couldn't get a fair trial. So why don't we zero in exactly what those allegations are? Because there's a lot of allegations that aren't legally sufficient, and there are some, in my mind, may meet this threshold, and I want to see what you think.
Yes, Your Honor, and you are correct. And I think that I agree. There were certainly some allegations in there that referenced perhaps trial counsel being unhappy with the judge's rulings that would not rise to that level. However, things such as comments made to counsel for Mr. Moore. Instances in which the court, when it takes the bench, and this was referenced in the motion prior to expert testimony from Mr. Moore's CPA accountant, that was critical testimony in this case, and the court makes the statement that, well, unless something really, really, really odd happens today, it's not going to change my mind. That's significant. That is certainly an indication that the court has prejudged the facts and the arguments and the issues before it. Again, that was prior to Mr. Marigellano's testimony, which was...
That, a little bit closer to what the exact quote was on that?
I do. I'm sorry, Your Honor. We have it in the brief. I do.
Exactly what he said.
What was said... I'm sorry, Your Honor. Hold on one second. The court walked in and upon... made the comment...
I don't want to...
No. It's important. No, Your Honor. It's important. The court said, I spent a lot of time on this case last night after we finished, and while I told you all yesterday I was not going to rule from the bench, I'm still not going to, but with the amount of time I've spent in the case and preparing for it, unless something really, really odd or strange happens today, it's not going to affect the outcome of this case.
Well, I think you did a good job in your brief in detailing what was said, but as if you look at this motion, it doesn't say anything about that whatsoever. It just says you're restricted from citing case law. The court has allowed last-minute evidence. It doesn't even go to describe what it is. The court is impatient with counsel. What does that mean? The court disregarded previous testimony. What does that mean? The former wife was disrespectful. The court I could tell by the court's body language. Where is this factually sufficient? Plus, she even goes out of left field, beyond the ballpark, beyond the bar, beyond the neighborhood, and starts citing the Zanovi case. You're mad at me because I represented somebody else in another case. How is this legally sufficient at all?
Well, Your Honor, I believe in the record or in the motion it was point J, and while trial counsel did not certainly quote the quote that I just read to the court, again, this was filed within, I believe it was like an hour of this happening, and what was alleged in the motion is the court's statements when it came onto the bench this morning made it clear that the court had made up its mind on how to rule. No testimony, argument, or case law will affect the court's perceived notion. And again, I believe that while certainly perhaps counsel could have paraphrased more or attempted to quote what was said, counsel didn't have the benefit of the transcript like we do now. But certainly by making that statement, the court is presumably aware of what it just said.
But if counsel's not going to follow the rules and provide an actual factual foundation to show the alleged fear of prejudice, if she's not going to follow the rules and it's going to simply say, the judge doesn't like me, that's not going to fly.
I would agree with Your Honor if that's all it says. Certainly saying the judge doesn't like me is not enough, but
there's nothing objective in here. There's nothing the judge said. It's her conclusions.
I would disagree, Your Honor, to the extent that, again, while I think some of the allegations perhaps are not sufficient, I do believe that allegations that the judge allowed invasion of attorney-client privilege. I think that is something that is not a subjective statement. That is something that occurred. That was something that was raised.
Yeah, but you didn't argue that in your brief.
We did, Your Honor. We quoted, respectfully, Your Honor, I disagree. We actually quoted the entire, we quoted what was alleged in the motion, which that particular comment is G. And we did discuss in the brief the fact that, and kind of explain the context of how that occurred. There was a break during testimony, and when we came back, when the judge came back from the break, there was a discussion with the former wife, had asked counsel if the former husband had spoken with the client during the lunch break, and again, this is G of the motion that's quoted in the brief, and then what is alleged is cross-examination of the former husband was allowed to occur, and the allegation is the court, without any authority of law, sided with counsel for the former husband and allowed invasion of attorney-client privilege.
You've been in okay. Well, was it improper? Was it actually improper for a trial counsel to say, did you discuss the case during the break? Have you ever...
I don't know if that would have been improper, but to the extent to which it then progressed, where the court then questioned Mr. Moore and asked him what was said, and it got into that. And again, part of While that may not have been sufficient legal error for reversal in and of itself as a error of law or an abuse of discretion, when you're looking at whether it is sufficient for a motion to disqualify, it's whether a reasonable person, not even someone in the legal profession, it's not a judge, a lawyer, it's whether Mr. Moore, based on what he's seeing, what he's being told, what is happening around him, would have a reasonable basis to believe that he is not receiving a fair trial. And having that type of questioning in the court asking about privileged communications, I think does rise to that level. I also believe, Your Honor, part of what's alleged that is objective and not subjective are the statements that the court said it could tell by the body language of a person whether or not someone was lying, and that was only said to the former husband, and that's specifically alleged. So again, if you're looking at it from Mr. Moore's perspective, these are all things that cumulatively, individually and cumulatively, lead him to believe I may not receive a fair trial. The interaction with, the former representation, again, while that may not be reasonable for counsel, I believe perhaps Judge Sleet's thought was for counsel to sort of have that belief, and that may not be sufficient. When you're looking at the client, and you're looking at Mr. Moore, who is, based on the other allegations, sort of seeing this perceived favoritism toward one side versus the other, and whether it's by rulings that are appropriate or not, that is still what is being perceived. And then you have your attorney explaining that there is this prior interaction where counsel believes, rightly or wrongly, and again with a motion to disqualify, we're not looking to whether the facts are accurate, we're looking to, they have to be taken as true. So now you have counsel saying, hey, I had this prior interaction with the judge in this other case, and it was kind of bad, and the judge, it says that she explains sort of the facts of that case.
They have to be true, but they can't be conclusory.
Agreed.
According to the language of the rule.
Correct. Yes, it has from a reasonable objective basis. But again, I believe...
The rule requires reference to something that occurred in the proceeding. Whether she represented somebody else some other time in front of this judge is not compliance. That's not what the rule contemplates. So that's what bothers me about this motion, is she's gone outside the lines and has said to this judge, because I represented A, B, and C, you're mistreating me. That's a problem.
And I think that the way it was presented, it wasn't, simply because I represented ABC, you have a problem with me.
That's what it says.
No, but it also says that at the end it says Judge Tibble's anger at counsel over that case has permeated his demeanor in this case. So, but again though, so it isn't just you're mad at me over that, but it's, hey, you're mad at me over that, but now you're acting differently toward me now. You and I could have had a bad interaction a month ago, and you come in now, and it's good. So I have no reason to think you're not going to be fair and impartial. But if all of a sudden you start acting unreasonably toward me, I think it's reasonable for me to go, now I wonder if it is because of that interaction.
You have to describe what the unreasonable actions are, though.
Excuse me?
You said the supposition in the motion is that the unreasonable actions of the trial court were based on consternation regarding the Zinovoy case. But we go back to the non-conclusory allegations. The unreasonable actions that have been described sufficiently.
But I think what it's, but if you look at it as a whole, then I think it's referring to the questioning, getting into the attorney-client privilege information, the not allowing evidence and testimony to be presented. That's not a disagreement of a legal ruling necessarily, depending on how the cumulative effect of that.
Does the motion talk about what evidence was not permitted to be admitted?
It references the court not allowing counter evidence to the former wife's lately produced evidence. It does not specify what that lately produced evidence was. But again, this was filed.
That's a ruling on the evidence, right? And the case law basically says that's not something we should consider.
Yeah, I agree, Your Honor, yes. But what I feel is a little different with this, again, though, is that it wasn't just and when you read and I know you have, but when you look at the transcript as a whole, there was a lot that was going on in this case. There was a lot of back and forth with the judge. And I think that while perhaps things could have been said more artfully, I think that what was trying to be conveyed or what was being conveyed was not just a disagreement about, no, I'm not going to admit that because it's irrelevant. It wasn't an evidentiary ruling in that sense. It was, well, I'm not going to let you do this.
You're at 15, just so you know. Do whatever you want.
Thank you, Your Honor. But regardless of that, Your Honor, all of those, the issues with regard to the disqualification permeate and then go into the modification, which, again, I'm going to have to rely to a large extent on my brief. I believe we did fully, brief that issue. There was, again, extensive testimony and evidence that was simply not considered by the court. And we are certainly aware that in an abuse of discretion standard, that it's an uphill battle, and I don't pretend not to know that. But what I will say is I do believe that this is not sort of not that any case is typical, but a typical case in which it's okay, there's this evidence and there's this evidence. When the totality of the evidence is presented, and when you review the trial court's order, there's simply testimony and evidence that was wholly not considered by the court. The court focused extensively on Mr. Moore's assets rather than focusing on whether Ms. Prince, the former wife, is able to contribute to her own finance, whether she's her need, for lack of a better way to put it. And in fact, the judge appeared to be of the impression that both were needed, that there needed to be a lack of his ability to pay, and she had to be able to pay for herself, and it's an or. So while certainly we think there was significant testimony and evidence that Mr. Moore's income decreased by 59%, part of the settlement agreement specifically provided that he retained all rights and interests to his pensions and to his investments. Ms. Moore received, or Ms. Prince in the divorce received a significant portion of his 401k.
That doesn't mean, you can correct me if you think I'm wrong, that doesn't mean that asset can't, if you have income from that asset, it can't be calculated as income for the purpose of determining ability to pay alimony. Is that right?
Not for determining the ability to pay alimony, but in this case, the argument was that what supported the modification or termination is the fact that the agreement was, this is wholly mine now. So,
She's not asking for the pension, she's asking to have the same alimony payment.
Correct, but that's the only asset from which he's able to pay that. Because his income is now just his Social Security and then those investment assets, and it's a 59% reduction. So, and again, there's the court referring to testimony and evidence regarding the son's income as a red herring demonstrates a lack of consideration of significant testimony and evidence that did show that, in fact, the former wife was able to, did not need the alimony, and that his ability to pay had been significantly diminished given his retirement. Thank you.
You've got 2 left. Okay.
Good morning. May it please the court. Kim Hamill of Older Lundy and Alvarez on behalf of the appellee. Eileen Prince, formerly known as Eileen Moore.
So to help me out, because
Yes, sir.
there are a lot of allegations about what this judge did to make this party feel uncomfortable about getting a fair trial. And some of them clearly are evidentiary rulings outside the scope. Others are just basic allegations with no facts that we can understand it. Go to the ones that worry you the most. I want to know which ones you think are the closest to being right, and tell me why you don't think they're right.
Understood, Your Honor. And that is a little bit hard to do because the motion leaves us guessing as to what portions of the trial and the hearing the former husband is referring to in his motion. As Judge Sleet said, there's no citations to any portions of the transcript, and if this motion was filed just an hour after the
There's an allegation here, the trial court directed the invasion of the attorney-client privilege. Now, we're supposed to take that as true. Whether it's true or not, it's irrelevant for purposes of the motion, right? We have to look at that and say, wow, that's serious. That's a pretty serious problem. I mean, if that allegation is true, and this court directed the invasion of the attorney-client privilege, wouldn't you think any reasonable litigant would say, I'm not getting a fair trial in front of this judge?
If, in fact, it was true, Your Honor.
Well, but we have to take it as true, right?
Yes.
Yeah, we can't look behind the truthfulness. That we just have to assume it's true. And Judge Tibble, sitting below, had to look at this and go, I don't get a chance to dispute that. If that's true, would a reasonable litigant say, I'm not getting a fair trial in front of this judge? the trial court directed the invasion of the attorney-client privilege. That's pretty serious.
I think the issue is the sufficiency of it. The rule is very clear that the motion has to sufficiently, specifically allege the bias. And a blanket statement, a blanket motion in this court has held in the Caro v. Florida Bar case, which is the second DC8 case, it really touches on the sufficiency that is required. You can't leave the court guessing as to the allegations made in the motion. So if there was sufficiency as to when that occurred in the 4 days of trial, and what the circumstances were surrounding that breach of privilege, we might get to the level of sufficiency required under the rule. But the blanket statements, invasion of privilege, objections, more objections overruled than for the former husband than the former wife, there has to be sufficiency. Otherwise, motions for disqualification would be filed left and right without everybody would be disqualified.
So the same would be true for the allegation the trial court aided trial counsel for former wife. Is that your same argument for that? There's just no facts, it's just a statement?
Correct, Your Honor.
Okay, how about this one? The trial court personally and aggressively questioned Mr. Moore while refraining from questioning the former wife, even when the evidence established the former wife had fabricated numbers on her financial affidavit. That sounds like not fair treatment.
Well, Your Honor, the
And
court, it's a
that's
bench
enough
trial.
facts
The
that we
court
know-
is able to inquire
Yeah.
of either party on issues that it has, and that's really, it goes to the presentation of evidence and the preparedness and the topics of the direct and cross-examination of each counsel and of each party. So if counsel wasn't hitting on specific issues that Judge Tibbles was curious about, he has the right in the bench trial to ask those questions.
Can you talk about the issue that, maybe we don't all have to agree this is what it was referring to, but I think we can assume that it was referring to the comments regarding the discussions of counsel and the client during the break that had to do with the invasion of the attorney-client privilege? In other words, having read the transcript of the trial court questioning which is asking questions that opposing counsel said invaded the attorney-client privilege, can you address that?
What actually the questions were?
Yeah.
well-
You say that we know that's what they're referring to. Granted, on the face of the motion, it's not clear,
It's-
but we
right.
know now what they were referring to. We can assume so.
We can
So
assume so.
why was that not sufficient to instill in the party a fear of bias?
Well, if you read the transcript, it's clear that discussions did occur, and that is an issue. The witness was on the stand. And if you look to the other portions of the transcript, there was actually a time where the former husband's counsel was inquiring of the former husband about privileged issues, and the court said, whoa, be careful, you're getting into attorney-client privilege. So I think if you read the transcript in its entirety, the court did have a fair consideration over all the evidence and all the questioning that occurred during this trial, specifically on that topic. He paused when the former husband's own counsel was inquiring or getting into issues of attorney-client privilege at another point in time in the trial.
It's fair game to cross-examine a party to say, did you talk to your counsel during the break? And you get the answer and you live with it. If the answer is yes, why should counsel or even the court be able to penetrate the attorney-client privilege to find out what they spoke about and the advice counsel gave? And that's what that's apparent here, is the court went further. Not just to say, hey, did you talk to your attorney during the break? Yeah, well, what'd you talk about? Is that crossing the line?
It could have been about lunch or about the substance of the case, and I think that that's really where that question was turning on, was did you talk about the substance of the case? And because if they were just talking about what they were eating for lunch, it could be a meaningless discussion for purposes of the court's reliance on that answer of yes or no when we had discussion. And again, I think the real issue here is the sufficiency of the motion. That's when the order denying the motion was entered, It's for lack of sufficiency. We can't just wonder what the former husband is referring to or talking about. And the former husband relies on the Wargo case, which is a 4th DCA case, and the former husband says it's instructive. And it is in some sense, because that case, the facts, the trial counsel stipulated it was a contempt hearing. The former husband wasn't there. The parties stipulated they weren't going to address the contempt, and the trial court made several comments. He's not here. He's already anticipating a bad result, is he? And then because the IRS had taken $40,000 out from the former wife because of the former husband's debt, the trial counsel said, well, this is atrocious. And then the parties agreed that they weren't going to address the contempt issue. Trial court got upset and then held him in contempt and ordered him incarcerated for 5 months and 29 days and 23 hours. And it wasn't really till the court got to the violation of due process. And if you read the Wargo opinion, it talks about how these comments that the trial court made weren't really sufficient, and the dissenting opinion touches on that as well. It's really when the court got to the due process and throwing him in jail and all these other issues, absent the stipulation of counsel that they weren't going to address the contempt issues, that we got to the sufficiency of the disqualification. So the Wargo case also cites to a couple of cases that say the mere characterizations and gratuitous comments, while offensive to litigants, do not in themselves satisfy the threshold requirement of a well-founded fear of bias or prejudice. A judge may form mental impressions and opinions during the presentation of evidence. And this case is also unique in that this was before the General Magistrate Proctor. Judge Tibbles, by stipulation of the parties, took the case in the middle of the hearing because General Magistrate Proctor retired, and then had to review the transcripts, understand what evidence was admitted, and the GM hearing was very convoluted from a transcript and evidentiary standpoint. And now we're in day 4, and cumulative arguments are being made, and the trial court basically said, I've read everything, I've looked through everything in detail, and let's move on. Because arguments were being made over and over and over again. And so it is unique in the sense that procedurally Judge Tibbles sort of adopted this case halfway through. So
Are you satisfied that we can hear this, we can review this, the denial of this motion procedurally?
I was just getting to that point, Your Honor. So by the law of the case and the law of this court, the first motion to disqualify, this motion has been incorporated into every single other motion to disqualify that has been filed. 2 writ of prohibitions have been filed. Orders denying both of those writs of prohibition have been entered. The 2nd and the 5th motion to disqualify. Every single motion has incorporated this initial motion, these facts, and so by the law of the case in this court, to reverse on the order denying this motion to disqualify would be inconsistent with the prior orders of this court.
And is there another ground that you would, I recall you arguing a separate ground, or it was intimated by the other party in its brief that because a writ wasn't taken, the right to appellate review is extinguished, it's waived.
I agree that it can be brought on this appeal. It just from a standpoint of knowing that the fee issues were coming and reserved upon, and an order was presumably coming, the reasonableness and the actual fear of Mr. Moore, I think that the time frame of actually seeking the review goes to perhaps the fear, reasonableness or not of Mr. Moore on the issue. Turning to the pension issue, I think it's black letter law. It's the Aker case out of the Florida Supreme Court to agree with the former husband argument that his pension should not be considered income for purposes of ability to pay alimony is wholly inconsistent with the case law.
It's apples and oranges, isn't it?
61, yeah, we're blurring equitable distribution and alimony in this argument. Aker is on point factually. They talk about a different case where the former wife received half of the pension in the underlying proceeding, and then they used they didn't carve that out when talking about the husband's ability.
But the reality of it is, indirectly, his pension is being compromised to meet this requirement after there had already been an agreement that the pension was off limits as to her. So
For
I mean,
purposes of equitable
It's a fair
distribution.
argument, there's no question about it. That's the reality of what's really happening. But
Right.
there is a difference between alimony and equitable distribution, and that's just the way it is.
Correct, Your Honor, and the former husband made a similar argument, sort of, I wanted to apply to the former wife, but not to me, by trying to impute investment income from all of her assets that she received from equitable distribution. So it sort of has to go both ways or neither. With regard to the argument that the former wife does not have a need, the former husband alleges that the trial court ignored a bunch of evidence. And if you go to that portion of the initial brief, it's page 44, it summarizes all the evidence that purportedly the trial court ignored. But there's not a single record citation or specific factual assertion as to what evidence was ignored. I think if you're going to allege that the court ignored evidence, we need to know specifically what exhibit or what portions of the transcript in order for the court to make a meaningful review on abuse of discretion. What evidence was ignored and where is that in the transcript? And there aren't any record citations to support that argument in the former husband's brief. If the former husband's alluding to the testimony of Mr. Peroni or Mr. Maglione, the court has the ability to weigh the credibility of the witnesses. It's not the appellate court's job to review the credibility issues. And the trial court made a specific finding that Mr. Maglione's testimony was not credible. So from a standpoint of abuse of discretion, I don't think the court can find that no other judge would have ruled that the former wife does not have a need any further. And ironically, the former husband more or less proved that the former wife has a need for the alimony because he started at the commencement of his supplemental petition to take his alimony payments and send them to his attorney's office throughout the entire proceeding over many objections. So the former wife was deprived of her alimony for this entire proceeding, which was very lengthy given the fact we were the general magistrate and then Judge Tibbles. And during that time, her net worth decreased by almost an average of the same dollar amount per month from the time of the original financial affidavit to the time of trial. So her net worth, her assets, her liquid assets decreased because she had to support herself during this trial for lack of receipt of her alimony payments. The former wife presented her own testimony through an expert, Kathy Mills. She applied a 3% rate of return across all investment accounts for both the former husband and the former wife, a very, very reasonable position to take. And with that, the experts still found that the former husband had a significantly greater net income as compared to the former wife. Counsel didn't touch on the life insurance issue because from timing standpoint, but it's very clear from the record that it was only addressed in closing argument. Ms. Coleman brought it up in closing, saying that the former husband is no longer employed and therefore he can't maintain the life insurance policy. There's no testimony, no evidence by an expert.
I'm assuming the life insurance was a policy he received through his employment, right?
Presumably,
Let's
yes.
say, what if there had been evidence adduced that the policy, that he was, by virtue of retiring, no longer permitted to be insured, and he had to procure it himself through another policy? Would that have been sufficient, given this stipulation of the parties in the previous judgment, to relieve him of his obligation? In other words, he is still insured under a policy that was provided by his employer, or that he received by virtue of his employment. So he has the money to pay the premiums, so that's fine. I'm assuming that's your argument. But my point is, what if there was, would you feel differently if there was evidence that he was dropped and they had to get new insurance?
I think the court at that point in time can review whether or not he has the ability to pay, he has the coverage, whether it's reasonable, and whether or not a modification is necessary.
But the agreement said until such time, only so long as he is able to procure this insurance through his employment.
Yes, if those were the facts, I think we would look at it that way and perhaps stipulate that would occur. But The fact is, he was also receiving a pension from his former employer. There's a lot of pension benefits, survivor benefits, and other mechanisms that are available, especially as a pensioned former employee. And so to make an assumption that he doesn't have those benefits was frankly what the former husband is asking the court to do. And that's not what the trial court's supposed to do. The trial court's supposed to look at competent, substantial evidence to prove the modification, and that wasn't provided by the former husband at all. I mean, not even by his expert. And there's a life insurance payment on his financial affidavit, so we're to assume that he has some sort of life insurance payment or the ability to pay life insurance. And with that, if there are no further questions, the trial court should affirm the order on appeal, as well as grant the former wife's motion for appellate attorney's fees and costs. Thank you.
Thank you. Again, briefly, because I know I only have a couple minutes, but to address one of Judge Atkinson's points, law of the case would not apply to preclude this court's consideration of the motion to disqualify. In fact, this court would not have been allowed to consider these specific allegations when considering, for example, the writ of prohibition with regard to the fifth motion to disqualify, because these facts all occurred at the time that this motion was filed. And
So let's say an attorney includes time barred in your argument allegations about the trial court's activities in a subsequent seriatim motion. The first one's not taken up on a writ of prohibition. The latter one is. So the latter one refers to what it considers to be what you consider to be time barred allegations. Is there possibly a perverse incentive for attorneys, not that this happened, I don't even think that it did, but to file a motion to disqualify, not seek a writ of prohibition, file another one more than 10 days later, preserve this one for plenary appeal, and yet take subsequent ones up on writ and a petition for writ of prohibition, and somehow sandbag both courts?
but
Judge Atkinson has taken most of your time. I'm going to give you another minute.
I appreciate that. Respectfully, I disagree that that's how that would occur, because again, while certain facts may have been included that were, say, superfluous or didn't need to be there, but provided a factual basis for, hey, this is what this case is about, when this court, I am fairly confident that when this court denied the writ of prohibition with regard to that fifth motion to disqualify, that denial was based on a review of only the facts alleged in that fifth motion to disqualify that were specific to what had occurred, whatever, the month before, shortly, right before that proceeding. That's how it works. Well, you can't use the prior facts. And so there is no law of the case. I mean, that's equivalent to, I was going to try to make a PCA reference, but I can't right now. I mean, it's just you don't know just because it was denied, it wasn't denied because this court found that none of the facts formed a basis. It was that the appeal from the fifth motion to disqualify, for example, was insufficient. This motion, however, is still being viewed under as Judge Morris has discussed, was there a reasonable basis for a litigant to feel that they would not receive a fair trial? And while I will agree with the court that some of the allegations that we've discussed today that are included in the motion, while perhaps, may make an individual feel bad or think that maybe it's unfair, they don't provide a reasonable basis because they are subjective. However, the comments such as invasion of attorney-client privilege, that is sufficiently pled and the facts are presented in the motion that would give a reasonable litigant, and that alone, a fear that they would not receive a fair trial, in addition to the comments regarding, and again, there was a factual basis provided that the court was aggressively questioning Mr. Moore. Again, some of the questioning.
Well, I'll finish up. I'm sorry to take your time, but
No.
I understand your point. I was raising a different point. This court is going to review the motion based on its merits, as did the trial court. And
I
thank
have
you
no
for
doubt.
entertaining my question.
I have
Sorry
no
for
doubt.
taking up your time.
Thank you, Your Honor.